Good evening, and welcome back to the conversation. We are very pleased to have you this evening. My name is Michael George, Senior Development Officer of the Catholic Foundation. And the Catholic Foundation is very pleased to be presenting this second session to you this evening. In honor of our presenter, Mike Lynch, why don't we start our time together, as always, in prayer. In the name of the Father, and of the Son, and of the Holy Spirit, amen. Saint Michael, the Archangel, defend us in battle. Be our protection against the wickedness and snares of the devil. May God rebuke him, we humbly pray. And do thou, O Prince of the heavenly host, by the power of God, thrust into hell Satan and all evil spirits who wander through the world, seeking the ruin of souls. Amen. In the name of the Father, Son, Holy Spirit, amen. While our first program on Monday night focused on the spiritual and the pastoral aspect of end-of-life issues, tonight we're taking a little bit of a turn. Tonight we focus on the more practical and temporal side as we approach end-of-life issues concerning legal considerations. Since we want to get right to our program, and many of you attended the program on Monday evening, we're going to have a Cliff Notes version of housekeeping items tonight. So, as always, attendees will be muted, but be sure to use the chat function to submit your questions throughout the presentation. In order to view the presentation in optimum mode, please click on side by side and also full screen mode within the view options. Also, even though we're going to take questions during the program, we will have a more formal question and answer after the program. And finally, for the benefit of all, please try to keep your questions general or broad in nature. It'll just help everyone to have a good experience. So once again, thanks for joining us, and we hope that you enjoy the conversation. So just real quickly, why do we want to talk about end-of-life issues? It's essentially because people feel uncomfortable, and as a result, they don't plan. And that becomes a problem because it means that other people are going to be making the decisions for you. But when you have good information like that, which is going to be presented tonight, the situation changes. You actually start talking about these issues with your family. Your wishes are known. And not only that, but when that time comes, you have the opportunity to have family focus more on family and less on a laundry list of tasks that need to be accomplished at a very difficult time. So, having said that, I would like to introduce Elizabeth Murray, Senior Development Officer at the Catholic Foundation, to introduce our speaker. Elizabeth, take it away.
Thank you, Michael, and good evening, everyone, and welcome back. Tonight, I have the honor of introducing to you Mike Lynch, who is the founding member of Malouf, Lynch, Jackson, and Swinson. Before retiring, Mike practiced law for 40 years, advising clients about a variety of tax, estate planning, and retirement issues. He taught at SMU's Dedman School of Law, served on the Duke Estate Planning Council, lectured at various tax and estate planning events, and has been recognized by several organizations for his accomplishments and service. Mike is a graduate of Notre Dame and holds a law degree from both Duke and SMU. Mike, the floor is yours.
Thank you, Elizabeth, and good evening. And I want to echo what Michael has said as his introduction. Tonight, it's really about what you want and what you don't want. Last year, before the COVID hit, there was a survey taken of a lot of people, different age groups, and one of the key questions was, do you think it's important to have your affairs in order, your estate planning documents done, trusts, whatever? 70% of the people said very important, 40% said yes, it was important, but they hadn't done anything. And when you look at the survey and break it down by age groups, a very high percentage of those 65 and older said it was very important, but their accomplishments weren't quite as good as they should have been to statistically bear out what they were saying. Nonetheless, we're here tonight to talk about legal considerations. I want to start with some basic background information. We're here in Texas, and we have a community property state. Community property is simply everything that a married couple acquires while they're married. The other type of property we have is separate property. And this becomes important as we get into discussing what happens to your property when you pass away. If you'd like to check as to what happens to property if you don't have a will, there are a series of rules in Texas called the intestacy law. It's just a fancy term for the rules that our state has legislated and govern what happens when you die if you own community property or separate property. And I'm not going to go into all of the different scenarios. You can pull it up on Google if you Google Texas intestacy law, and you'll find the different charts and scenarios. But it makes a difference the type of property you own, whether you're married, have children, whether it's a second marriage, whether you're single, etc. So the state has written a will for you, and the question is that what you want to have happen? Or do you want to take, if you will, the bull by the horn and document what you want? To me, there are three certainties in this area. There's death, that will occur. Property, everyone owns property, and it will pass. As I said, we have in Texas laws that say what happens if you don't have a will. And the third are taxes, which are relevant even if you have a relatively small estate. Let's talk about death first. Last year, Dan Jenkins died. He was quite a sports commentator, writer, humorist, and he was interviewed shortly before his death, and the person asked him, Dan, you've written a lot. Have you decided what you want to write on your tombstone? Dan replied promptly, yes. I knew this would happen. Well, we all know that this is going to happen. And so let's discuss what we can do about it. Because as I said, everyone owns property. Title to that property will pass when you die. The state has a will for you if you don't do one yourself. And everyone has some kind of wish or desire, general and specific, about what they want to have happen when they die. Now, there are probate documents and non-probate documents that are important. And I want to talk first about the non-probate documents. In other words, those documents that don't have to be taken to the probate court, but that are important in guiding the people who will take care of your estate and letting them know what you want to have happen. The first I want to talk about is a power of attorney. And there are two types of powers of attorney: financial powers of attorney and medical powers of attorney. A financial power of attorney is a document that you sign and you express in that document what you want to have happen to your financial assets if you're unable to make decisions and communicate those to others. For example, who would pay the bills if you're unable to pay them? Who would take action with regard to your financial assets, the sale or stocks or bonds, the handling of mutual funds, IRAs, etc.? Who would take care of your bank accounts? And in doing a financial power of attorney, you can specify whether they're effective immediately, for a short period of time, you're going to Europe, or you're going to be not able to communicate, and you want someone to be available if something needs to have happened to your financial assets. They can be durable or non-durable. And a durable power of attorney simply means that you name someone or a series of people, they take care of your financial matters, and if you happen to become disabled, the power of attorney is still good. The second type of power of attorney is a medical power of attorney. This type of document expresses and appoints individuals to act on your behalf and make medical decisions. You say, well, why would this be something that's important? Let's take an example. You're in an automobile accident and you're unconscious, you're taken to a hospital, and the doctor wants to perform some type of procedure or operation or administer some type of medication. We have our powers of attorney, my wife and I have ours on file with our doctor, and he can pull up on his computer the medical power of attorney. And if I were in an accident, taken to the hospital unconscious, and our doctor wanted to take some kind of medical action, he would know that he could talk to my wife and she would be able to act on my behalf. The slide shows the HIPAA release form notation, and that's important. HIPAA is a law that was passed several years ago that basically protects the privacy or ensures the privacy of your medical information. You have to grant permission in order for medical information to be disclosed. I like to have a HIPAA release form in the medical power of attorney so that, for example, in the example I just mentioned, if something were to happen, the doctor could disclose anything about my medical past to my wife, so that would be could be relevant to making the decision as to what might have to be done. We move on to Directive to Physicians, which is another non-probate type of document. We're moving now from medical issues to end-of-life issues, where you have a fatal condition or you're in a situation where it is an end-of-life decision. And this document allows you to express your desires as to what you want to happen if you are at the end of at the end of your life. Do you want to appoint someone, for example, to make the decision to remove you from artificial life support if you are on that, or to administer artificial life support if you need it, and you're not able to tell the doctor yes or no? It's a very important document in my estimation, and again, it's a document that if you do, you want to be sure to have on file with your doctor, so it's readily available. A more recent development, most that I've noted, a medical order for scope of treatment, is not statutory. The powers of attorney that I mentioned, financial power of attorney, medical power of attorney, and directive to physician, are all authorized by statute, and there are statutory general forms that you can download from texasgov.com. Medical order for scope of treatment is a situation where you may have a fatal medical situation, and you know that the end of life could be near, but you want to consult with your doctor and decide specifically what you want to have happen if certain things occur. An example, we had a friend recently who had neoblastoma, and she was in failing health, and she wanted certain things to occur if the condition went one way versus another. She consulted with her doctor. They did a medical order for scope of treatment. And so this supplements and complements the directive to physicians and allows you to be very specific with regard to a particular condition and your end-of-life desires as regards that condition. Next, funeral planning. This is going to be covered as a separate topic and a very important topic, but it's certainly important to set forth what you want to have happen. What kind of funeral do you want? Do you want to be cremated? Where would you like to be buried? Here? Do you want to go back home if you're from Ohio, for example? All these things are very important and save an awful lot of time and grief if you take the opportunity and specify what you want to have happen. In Texas, by law, you are allowed to write a binding legal document that tells people this is what's to happen if I die. I don't know if you've ever had the situation where someone has died or about to die, the family's together, and there's tension because one side of the family thinks that the person who's sick, who's about to die, who has just died, wants one thing, and another side of the family thinks that individual wanted something else. So I think setting forth your funeral decisions are extremely important. All of this wraps into what's commonly known as estate planning, or wealth planning, property planning. And the documents that I've mentioned go along with the probate document, your will, and oftentimes a trust is also involved in planning. A trust is simply a legal document by which you transfer title at some point to someone called a trustee, and that individual or corporation, trust company, or bank that deals in that area has the legal responsibility to invest your funds wisely and to distribute those funds as you wish at various times to various people. So all of the documents we mentioned earlier, the powers of attorney, the directive to physicians, funeral planning, along with your will and possibly trust, all go to answering the questions of who do you want to receive what? When do you want your wealth to be passed on? Who's to make those decisions? What contingencies are involved? Would it be outright or in trust? All the assets are wrapped up in the planning process. And the more that you, and if you're married, you and your spouse can sit down and talk these matters out, and I even suggest writing some notes, the better off and the more efficient the process becomes once you go and talk to an attorney to do the actual documents. And in talking about who, what, when, how, you also want to consider the what ifs. What do I want to have happen if I have children who survive me, and after I've died, one of those children dies and leaves children? What happens to their share of the inheritance I want to leave? What happens if my wife doesn't survive me? What ifs are an important facet of the whole planning process. I want to spend a little bit of time now talking about taxes. And I said at the outset that taxes are relevant. First, the gift taxes. I want to point out and clarify, because I've had questions about this in the past. You can give, each individual can give to any other individual up to $15,000 a year, each year, per year, and there are no gift tax consequences. No taxes due, no return has to be filed. So, for example, I have 5 children. If I wanted to try to minimize my estate and get rid of some property, cash, valuable property, stocks, whatever, I could make $15,000 gifts to each of my children in December, $75,000 in December, $75,000 in January, and reduce my estate by $150,000 if that would be appropriate tax planning. The second thing are estate taxes, and there are 3 areas here that I want to note. As our slide shows, we are now in an unusual time when we have a significant exemption equivalent. Any single individual can own and leave to anyone up to $11+ million, and there's no estate tax return due. There's no estate tax on that amount of money. A married couple, the husband has his own $11+ million, the wife has her own $11+ million, which totals up to more than $23 million that can be left tax-free. A very important part of estate taxes is what I've noted, the deceased spouse's unused exemption, or called DSU, in an acronym. What this means is that when one spouse dies, if the proper documents are filed with the Internal Revenue Service, what that spouse has not used of their exemption equivalent can pass on to his or her spouse, so that she or he would have that amount available whenever they die to leave a bulk of assets tax-free. That could become very important if we have changes in our tax laws, and I'll talk about that in just a moment. The second thing I want to note is the basis matter. What people don't sometimes recall or understand is that when an individual dies, the value of the property that they owned gets what is known as a step-up. Let me give you an example. Let's suppose I owned a stock that I bought for $100. and the stock is now worth $1,100. If I were to sell that stock the day before I died, I would have bought it for $100. It's worth $1,100. I would have a gain of $1,000, and I would have to report tax and pay tax on that. If, however, the next day I died and thereafter my executor or my spouse sold that stock, its tax basis has now gone up from $100 to $1,100, which means if my spouse sold the stock after I died for $1,100, she would have a tax basis of $1,100, no gain. And basis is important because you get the step up in basis even if you don't have a taxable estate, even if you don't have to file an estate tax return. So it's an important thing to remember in the event of a death. I noted that change proposals are in the wind. We've just had a $3 trillion infusion into our economy, and Congress is talking about whether or not we may get more money passed out to folks to help them. Who knows who may win the election that's upcoming in a little over a month. But with the debt we're mounting up and with some of the proposals that are out there, there could very well be some significant changes in our tax laws, and these could spill over into the estate tax. So watch to see what the winds blow as October and November arrive, because if proposals become realities after the election, there may be a lot of planning opportunities and necessity in a relatively short period of time. The last thing I want to talk about taxes is something that's very important, and that's called the Secure Act. It was passed December of 2019, and it fundamentally changes the way in which retirement plans, IRAs, 401ks, etc., are distributable after a person dies. Prior to the Secure Act, if I had an IRA in my name and we're taking out money, I'm over 70, I'm into the period of time of 72 now is a new age when you have to start taking it out, but I now have to take out a minimum amount each year. After I die, I can leave it to my spouse. She can continue to take out the IRA over her lifetime. Suppose then I've left it to her and she dies and leaves it to our children. They, before the Secure Act, could continue to take it out over a lifetime period. Congress looked at this last year and said, these monies are supposed to be for retirement. They're not supposed to be for inheritance. So we want to accelerate the time in which they have to be taken out. They have to be withdrawn after people die. The maximum time now for most beneficiaries, other than the beneficiaries I note, is 10 years. Congress estimated that by changing the law from life expectancy withdrawals to a 10-year maximum withdrawal for most beneficiaries, they would produce an additional $15 billion of income tax in the next 10 years. So there's a lot of money that's involved in this change. And if you have beneficiary designations that were done before December, which I probably think most of you did, it'd be well worth your while to sit down with someone and make sure that those beneficiary designations still fit what you want to have happen. Finally, always consider, if you're married, what happens after the first death. It'd be relatively simple in a marriage situation to pass assets from one deceased spouse to the survivor spouse, to do that in an outright or relatively straightforward manner. But then what happens after the second spouse dies? And what happens if there happens to be a common accident or a situation where the two spouses die within a short period of time and, for example, leave minor children? What happens to your assets? And as I mentioned earlier, what happens even if death is somewhat in an orderly fashion, but after the second death occurs, one of your children dies, leaving heirs who are minors? what happens to their share of the inheritance. So as I note, talk amongst yourselves. Talk with your spouse. Work out your desires with one another. Note your wishes. Make notes. Take them to an estate planning attorney. And sit down, I recommend, sit down with your children and explain to them what you've done, what you want to have happen, and what you don't want to have happen. Because it's your money, it's your right, and I encourage you to exercise it. I want to take a couple of minutes now and just go through a couple of scenarios which might illustrate some of the things I've discussed. Let's first talk about this illustration, which involves a married couple. They both work and have young children. As you can see from what I've listed, they have a nice amount of property, a nice home, some bank accounts and retirement funds that they're starting to build, some insurance, IRAs, 401ks. What type of disposition structure might you use for this couple? You might say at the first death that the surviving spouse receives everything outright with a contingent trust in the documents for children until they're 25. And this covers some of the what-if situations I mentioned. So that if the husband dies, the wife receives the property. Now it would probably be in trust, as I mentioned, or outright with a contingent trust for minor children. And the second spouse dies, the trust is there for the children until they're 25. A lot of the passage of title from the husband to the wife or the spouse to die to the second can be done through joint tenancy with right of survivorship or transfer on death documents. And beneficiary forms, remember I mentioned the Secure Act and beneficiary forms for IRAs and retirement funds, also life insurance. The beneficiary forms are one of the key non-probate asset documents that need to be completed and need to be reviewed periodically. I just turned 80 years old, and my wife and I are now, for example, in our fifth, I believe, modification, revision, update of our documents. The second illustration I want to talk about just a little bit is a single individual. This is a different part of the spectrum. And here, remember at the outset, I said that we have two types of property, community property and separate property. Community property is only involved when you're married. Community property is all property that a married couple living in Texas acquires while they're married. Single individuals aren't married, so all they have is separate property. In referencing the intestacy laws when I started, there are a series of scenarios that are in the law that explain what happens if a single individual dies and where their property goes, whether it goes to their parents or whether it goes to their siblings or how it passes. If a single individual is comfortable with that scheme, there will be probate likely that's necessary. There will be additional costs that are likely necessary because the probate won't be the most efficient. It'll be a dependent versus an independent administration generally. But an individual, single individual, could do a relatively simple estate plan that would take care of their property and make sure that if they, for example, wanted to go to their parents, that it would go to their parents. If they wanted it to go to siblings, it could go there. Again, a lot of this could possibly be handled with joint tenancy with right of survivorship and by filling out beneficiary forms in the proper way, and also by coordinating that by talking with the parents or with the siblings about what the individual wants to have happen. Let me move to my third illustration. This is a little more complex, a little more valuable, if you will, where we have a little older couple, married in their 50s now, 3 children, college grad, high school and grade school, a nice home, household furnitures and fixtures, 4 cars, of course 2 of them are driven by the children, bank accounts, brokerage accounts, a company stock that the husband owns, it's worth $350,000. This is a company that he founded, and what he's got set up is a buy-sell agreement so that the stock could be liquefied, in other words, turned into cash on his death, even if he wanted the wife to run the company after his death, wanted to sell to a possible partner who might be involved, or one of his children, possibly his college grad, to be involved. But it's a way that cash can be available to the wife and to the family to continue to support them after the husband has left. Also, some nice 401k accounts that you see listed there. And this probably involves a little more complexity. Joint tenancy with right of survivorship can be used for certain of the assets. The beneficiary forms for those 401k plans, for the retirement funds, and the life insurance are very important. And I've listed on this slide a possible approach to how all this property could be coordinated and disposed of so that it goes in an orderly fashion and the way in which the couple wants it to go: a first death, then a second death, then children thereafter, or what if both deaths occurred at the same time? All of that can be coordinated. I've talked about the non-probate assets and used these three illustrations, and I want to come back to something about the non-probate assets that I have found in my 40 years of practice, and even now in dealing with some of my former clients, is one of the big issues that occurs. You go into the attorney, you've made your notes, you've had your conversations, you bring your spreadsheet in, you've listed the life insurance, you've identified the 401k plans or the IRAs. Everything is set forth and documented very well. The attorney takes the information, drafts the documents, sends out drafts, you discuss them, makes the necessary revisions, you sign them, and the original documents are with the attorney. You get copies of your medical power of attorney that are filed with your doctors. The financial power of attorneys are filed with your financial advisor or bank so that they'll know what's to happen if you're unable to make financial decisions. All these things are in line, and you leave the attorney's office with the instructions about here's what you need to do, and here's the language that you need to input into your life insurance beneficiary designations and your 401k plan, IRA, retirement fund beneficiary designations. Right? We'll be doing that in the next week. We'll get right onto that. You go back home, family life occurs. You didn't do it the first week. Oh, it's on your follow-up calendar. It pops up on the phone or your computer. Yeah, we'll get to that. It's not done. And this causes an awful lot of heartache and complications. You can certainly have your attorneys take the action to handle those matters. It will cost you some extra fees to do that, but you can be assured it's done. But it is one of those things that gets hung out there and oftentimes is an item that produces an awful lot of tension and an awful lot of cost and an awful lot of grief. The second thing, or another thing, I shouldn't say just the second, but another thing I wanted to emphasize is talking about who, what, when, why, how you want things structured, how you want your wishes documented and things to happen or not happen. The second death and what happens after the second death is very important to think through and be sure that your estate planning attorney understands what you want to have happen if certain contingencies occur. I wouldn't think you can't cover all contingencies, but in my experience, well-drafted documents cover the bulk of contingencies and have enough flexibility in them to take care of unusual circumstances if they arise. Can things like improperly done beneficiary designations, for example, be taken care of? Yes. There are ways to correct those inactions or decisions that are made but don't comport with what you really wanted to have happen. But doing or correcting those deficiencies, again, causes time and money. Step back. Think about what you want to have happen, make some notes, talk about it, talk with your spouse if you're married, talk with your children, particularly with your adult children, talk with the people that you've named as your attorneys under the power of attorney, medical power of attorney. Talk to your doctors when you have your visit. Make sure they have the documents and they understand what you want to have happen. And I can assure you, you have gone a long, long way to assure a smooth transition whenever you happen to die. I'll go ahead now and we'll take some questions and answers. Hopefully some answers, but we'll certainly take some questions. So Elizabeth, do you have anything for me?
I do, Mike. There's a variety of questions. One of the ones that somebody has asked is regarding durable power of attorney. Early in the presentation, you spoke about a durable power of attorney. You also spoke about another document, and they would like you to kind of reiterate what that second document was.
I spoke about, I believe the question goes to powers of attorney. And I mentioned there are two types of powers of attorney. A power of attorney, by its nature, by its term, by its name, you empower someone to act on your behalf. You empower someone to do something. When you empower someone to take some action for financial matters, bank accounts, stocks, bonds, etc., that is a financial power of attorney. That is one document. As I mentioned, the state legislature has formulated a statutory power of attorney that covers the waterfront. It's available online from Texas government, texasgov.com, I believe it is. And there are instructions as to how to even execute it. I do recommend, of course, that you have an attorney do it, but it is there available so that you can look at the financial power of attorney and get familiar with it and understand more about what it says and what it does. The second power of attorney is a medical power of attorney. Now you're authorizing someone to act on your behalf. This is a separate independent document. You're authorizing someone on your behalf to take actions if you need medical assistance and you're not dealing with an end-of-life type of medical situation. This is more when you have an accident or you have a situation where you're not looking at a fatal situation, but you're unable for whatever reason to communicate to the doctor or the medical staff what you want to have happen, what medical procedures or medicines or whatever other type of medical help you desire. You're naming someone to make those decisions if you can't. It doesn't take away your power to do that. It simply takes into account the contingency that you may not be able to communicate what you want to have happen when you need to communicate it. You've authorized someone else to do that. And you have filed this document with your doctor so they know that it's there. Obviously, if you go to the hospital and the medical power of attorney is sitting at home in your safe or at your attorney's office, it doesn't do much help. It probably won't be available in time to do what it needs to do. Anything else, Elizabeth?
The question regarding charity.
All right.
It's regarding charity and the list of charities that a potential donor would like to list in their will. Can they make that list outside of the will and then have the ability to change it, or does that have to be listed within the will?
Well, it should be listed in the will. A lot of times, people who would like to leave money to charity prefer that their donations be more of a private situation than is in a will. And this is a good time to talk about the difference between probate and non-probate assets. Your will have to be probated. That is how it is effective in order to take care of your fulfilling your wishes as to what you want to have happen to your property. That is a public document. And so anybody can go to the courthouse, get a copy of your will, and understand what you said and who you said it about, etc. A lot of people use trusts, form a trust during lifetime, don't fund it. It's simply there as a receptacle to receive assets from the estate when someone dies, that the assets from the estate pour from the will, through probate, into the trust. The trust is a private document, and it's only communicated to the beneficiaries, the trustee, and that's pretty much the scope of the universe. So if you named charities that you wanted to benefit in your trust, it would be a way to have that done in a more private way than having it named in your will. But yes, you would want to name them in the will unless I would recommend, if you wanted to be more anonymous or more private, that you use a pour-over trust or some type of trust arrangement and name the charitable beneficiaries in your trust document.
Okay, thank you. Is the estate exemption reduced for the gift tax exemptions used?
I didn't understand, please.
The question regards the estate exemption. Is it reduced for tax exemptions used for gifts given to family members?
Good question. And let me take that question and elaborate on it just a little bit. I mentioned that you can leave up to $15,000 per year, per calendar year, per individual. So I could leave $15,000 to individual one, another $15,000 to individual two, another $15,000 to individual three, and it has no gift tax, estate tax consequences. It does not reduce the exemption. It is if you will, a safety net or an open avenue as a way to minimize or reduce a person's wealth, and obviously to benefit someone. If you, as an example I used earlier, if you were to give a gift of $15,100, or let's make it more reasonable. Let's suppose a person needed $30,000. You have a child and they want to buy a house. They're not married, they're a single individual. You and your wife could together give your child $15,000 a piece. That's $30,000. Suppose the down payment was $45,000 that they needed. So you've given to the individual $15,000 more than what's called the annual exclusion. In that instance, you would be required to file a gift tax return. You would report that additional $15,000 over and above the $15,000 apiece as a gift, a taxable gift. But since you have over an $11 million exemption, you would offset it against that exemption, and that $15,000 extra of gift would reduce that exemption by $15,000. So in that instance, yes, it would be reduced. I want to go back, though, to mention about the deceased spouse's unused exemption that I mentioned in talking about taxes. That's, again, a very, very important asset to have. And the IRS has ruled that there is no, quote, clawback of that exemption. Let me explain. Let's suppose that we have a change in our tax laws, whether it's a change in administration, a change because Congress decides we need to raise more money, whatever. And let's suppose, as some people are asking for and lobbying for, that our estate tax exemption goes back to $5 million. Now we've moved from 11 million plus that we have now per individual, in the example I used, back to $5 million. If a person were to die while the exemption is 11 plus million dollars and the person is married, the deceased spouse, with the proper documents filed with the IRS, could what they call port or give to the surviving spouse that unused amount of 11 plus million dollars for the surviving spouse to use. Now in my example, let's suppose the first spouse dies this year in 2020, and they haven't used any of let's suppose they use $1.68 million for their estate. So there's $10 million of the exemption left. The proper documents are filed, and that $10 million from the deceased spouse passes to the surviving spouse. Now the surviving spouse dies in a subsequent year when Congress has reduced the exemption to $5 million. Again, assuming the proper documents are filed, and with the example I've noted, the $10 million from the deceased spouse is added to the surviving spouse's new lower $5 million exemption. So the surviving spouse has the opportunity to leave $15 million in value to heirs or to others. So any death that occurs in a marriage situation, while we still have the higher exemption equivalent, and that, as I noted in my slides, will expire in 2026, assuming it's not reduced before then. If a spouse dies while that's still in existence, it can be passed on to the surviving spouse. And I think you can see very dramatically how important that could be for a surviving spouse to have for their own estate planning situation. Do you have another question?
I do. Does a spouse have tacit medical power of attorney, meaning absent a specific medical power of attorney document? Does a spouse have the authority to dictate medical power or medical treatment? Excuse me.
In a situation where there's not a medical power of attorney, there's a statutory priority, and the spouse would be the first person that would be contacted, yes.
Okay.
The problem you sometimes run into is next in line are other children, and there's a priority that's in the legislation. That's in the legislation. The medical power of attorney naming the spouse makes it very clear to the doctor who has authority. And it obviates a lot of possible disconsent and disagreement that often occurs, or that can occur, when you're in a medically stressful situation. My advice is use what the law allows, because it's there to help you.
Okay. Another question concerns living trusts.
Yes.
If there's a living trust in place, does it protect the beneficiaries from having to go to probate, or does everyone have to go to probate and the living trust shortens the process?
If the living trust is truly a living trust, separate and apart from the will, then it's a separate document. And what usually happens is the will says something like this: when I die, pay the expenses, pay my funeral expenses, pay my expenses of last illness. You authorize your executor to do that. You name the independent executor. You appoint the independent executor to conduct what's called an independent administration, where they don't have to go to court every time in order to get court approval of decisions they want to make. So the will is probated, an independent executor appointed, letters testamentary are issued that document and authorize the executor to act. The executor takes the actions, takes care of taking into account anything that needs to be paid as a result of the death, and then takes what's left and legally transfers that to whomever is named as the trustee of the living trust. The probate is closed. The trust doesn't get involved in probate. If, on the other hand, the trust is in the will, the same type of process happens, but the trust terms are public knowledge, and the trust is then handled as a testamentary trust. The estate would still be closed, but the handoff of the assets would occur through probate into a testamentary trust, and that trust would then go forward. Similar to the inter vivos trust, the difference is you don't have the documentation in the will. It's in a separate document, and it's more private.
Mike, our next question refers to the Secure Act. What is meant by 10 years younger than owner exception, since children are typically 10 years younger than the parent?
Well, there's two separate classifications. Generally, the children who are younger, minor children, are covered by one type of exemption. So that if you have a situation, I leave my IRA to I don't have any minor children anymore, but suppose I left my IRA to a minor grandchild who's 10 years old. That means that the IRA could be withdrawn and distributed over a life expectancy period until that minor child became 18, possibly later. We don't know that yet, but possibly beyond 18. But right now we think it's just 18. And then when the child is 18, the IRA would have to be withdrawn before the child is 28, 10 years later. Suppose that I leave the IRA to a child of mine who's 5 years younger than I am. Then that is the exception for leaving it to someone that's less than 10 years, that's 10 years minor or less.
Okay. Our next question concerns a second marriage. If the documents were created prior to the second marriage, what takes precedent? Are the old documents priority to the previous spouse? Or since there's a current marriage, is it assumed the current marriage takes priority? That is a great question and full of brambles. First of all, the documents that were done before the marriage, if there are no subsequent documents, they're still in place, they're still legal documents. And one of the things that too frequently happens in second marriages concerns 401k plans and employer retirement plans. Those plans are governed by federal law, and federal law has a spousal right type of provision in it. And basically, if I have a 401k plan, let's say I'm in my first marriage, and I have a 401k plan, and I have named wife one as the beneficiary. If during our marriage I want to change that beneficiary to name someone other than wife one, maybe even a trust for wife one, but someone other than wife one, I have to get my spouse's signature, and the plan administrator would require that before they would effectively allow a change in the beneficiary designation. So let's go now. We've done this. I'm married. I name spouse one. I then get divorced. Spouse one is still the beneficiary of that 401k plan. I marry spouse two, and I change my documents, my will, my trust, my everything else, and I say spouse two gets everything, but I neglect to go to my plan administrator and change that beneficiary designation I did when I was married to spouse one. I'm divorced. I no longer need spouse one's permission to change the beneficiary designation. I may need spouse two's permission, but if I'm going to name spouse two, obviously I would probably get that permission. But if I fail to change in the example that I posited from spouse one to spouse two, spouse one will get the 401k and spouse two is out of the picture. That has caused significant litigation and significant pain, emotional and stressful pain. So whenever you're getting a divorce or remarrying, have everything reviewed. And those beneficiary designations for even IRAs, 401k plans, life insurance, those are so very important and so often forgotten. Okay, that's great. One last question. If investments are held in a revocable trust, does a step-up basis occur?
If it is truly a revocable, what's known as a grantor trust, I set up a trust and I put all my assets into that trust so that they don't have to go through probate. I name the trust as the beneficiary of my IRAs with appropriate language. I put my fidelity accounts in the trust. I put my individually owned stocks into the trust. I even put my house into the trust, and that trust says it is revocable while I'm alive. I can change it, I can amend it, I can do anything I want to with it, and I die, the assets in that trust will qualify for step-up basis. If I have put those assets into an irrevocable trust that I cannot change, that I do not have power over to amend or modify, then they would not get a step-up basis.
Mike, please know how much we appreciate you taking such a difficult subject and making it easier for our attendees to understand. Thank you for your time, Mike. We really appreciate it.
You're welcome, Michael.
And also, thanks again goes to our CRAC Foundation staff whose efforts really make this happen. Director of Marketing and Communications, Bill Kula, Senior Development Officer, Elizabeth Murray, Administrative Assistant, Amy DeLeese, and our special guest for tonight, Executive Assistant, Linda Sheets. Many thanks to you all. And finally, our thanks to each of you for continuing to join in the conversation. Once again, if you enjoyed tonight's program, be sure to invite your friends to join us as well. We still have 2 more facets on end-of-life issues, and coming up on Monday, we will be going from legal to the medical, and we're going to invite at 7 o'clock Father Peter Fonseca from the Archdiocese of St. Louis. He will be leading a conversation on the principles of bioethics and basically how you're going to be treated from a medical standpoint, especially at that really crucial time of life. So please be sure to join us for that. If you are not signed up for that right now, you can go to our website just like you signed up before and be sure to enter. It should be a great session, and we look forward to having you then. And once again, thank you for everything. Thank you for joining us in the conversation. Thank you for your questions. One thing, any questions that didn't get answered during our conversation tonight, we will be posting a Q&A afterwards. So all of the questions will get answered. So with that, thank you and good night.